Okay. Welcome everyone to another episode of Echo. Um, Today is a very exciting and nerve-wracking day because now I gotta be serious. I got very serious people, important people with me today. They're taking time from their very busy schedule to inform me and some of you guys as to maybe dumb this down to a level that I can understand. Today we're gonna be talking a little bit about the discovery laws in New York, which, like anything, it seems to be always a hotbed of contradiction, whether it's good or bad. Um, so today we have Christine Callanan from the Waye County Public Defender's Office and James Riotto, public defense attorney, a private defense attorney. You guys want to introduce yourself, Christine?
Yeah, I'm Christine Callanan. I'm the district attorney of Waye County. Have just recently been elected, but have been a prosecutor for over 14 years, 7 years in Monroe County, and now 7 years out here.
Awesome. Thank you so much. Working with both of you, I know that you both have a lot of experience at it. So, Jim, James.
Yeah. James Riotto, criminal defense attorney, located in Rochester, New York. Our office handles cases throughout the state. About the same amount of time as experience as Miss Callanan, about 14 years. Before that, I was a trooper for quite a period of time as well.
So you got some experience on the road as well.
Correct.
Now, some of the things that I had been, reading into it like everybody else, it seems to be like, and now again, all this conversation started because a post that I saw on an interview that you had with the news, Christine, where you had brought up subjects where something like time restrictions and messing up with how you were able, or DAs in general, are able to work in the case. When this all started back in 2019, people were, already having issues with it. So I wanted to see if both of you maybe can provide us with a little bit of what were the issues before and what was updated. Because if I'm not wrong, this in the last few days, there was already the change got passed and everything got all the new rules, correct?
Correct.
So what do we expect now, like in your case as a DA? How did it change for you?
So when the legislation was proposed initially, a lot of the issues that were being addressed were from downstate in New York City. There had been a lot of issues with discovery, turning files over, providing information to defense attorneys. Jim could probably speak to it more. He's practiced more throughout the state as to that issue. In Monroe County, where I started, and in Waye County, which is where I was when this reform went in, we always had an open file policy. So we didn't withhold information. We didn't make those choices. The timelines were different then on when we would have to disclose things. So we did follow those timelines, but I came from offices and have always practiced in turning things over. That isn't the case in all offices across New York State, and it caused issues with defense attorneys getting informations, defendants getting informations and files, and paperwork. And so as a whole and a collective, they decided to address that by making basically what had been in place with the offices that I were already practicing in, codified in the fact that they had to turn over everything and basically had to have open file policies that weren't in place. But also in doing so, set up specific timelines that required the people to turn them over in a different timeline, and then also had punitive measures for any failure to do so, which was different from how we previously practiced.
Yeah, because normally in court, at least when I interpret, it's like, okay, you're supposed to basically give everything and everything, whether culpatory or not, and you have a time frame to do it. Now, I also understand it's different when states and federal and all of that gets mixed up in my head. What is the timeline? Like, because some of the changes is to address the volume, right? Like to give you an exception if the volume changes or something like that. I'm not, can you explain please?
So yeah, the timeline did change. It used to be more predicated on if there were hearings going on or prior to a trial that these things had to be disclosed by grand jury minutes, for example, which is a confidential proceeding, that people could withhold disclosing those until the time of trial or prior to a witness having to testify. Where I
Yes.
come from in Monroe County, when you were prosecuting homicides or highly sensitive cases like that, that was very beneficial for witnesses that felt scared or threatened. In this new era of, unless you can have an articulable basis for a protective order, we have to turn those kinds of things over immediately upon receipt as soon as possible. There are some extensions built in that we could ask for from the court, but basically the default is everything as soon as possible.
Well, but wouldn't it holding it back in, like how far back into the trial? Because these things can go for months or sometimes a year or two, right?
Our policy prior to discovery reform was prior to jury selection, any witnesses whose grand jury testimony hadn't previously been turned over for the purposes of hearings would be disclosed prior to jury selection.
I can understand wanting to keep the secrecy of the jury of the witnesses until that minute. How does that affect the defense? Like in your case, if evidence has been turned all the way to the end of it, how did the new changes? How do you see those?
Well, candidly, I think it was helpful. I mean, at the end of the day, we really just want to be advocates for our clients, and having as much information readily available about what was going on as early as possible helps clients make informed decisions on how to go forward. Prior to 2020, a lot of police reports, a lot of statements, a lot of things that we're getting now, we didn't get. We didn't have that information. So,
Can we get an example?
yeah, there could be prior, let's see, if the person had been in trouble before, or if there was other issues with negative, negative information about maybe one of the officers, something like that. We wouldn't necessarily get that till right before trial. And I don't think I had that experience in Monroe County, but there were other counties where we'd walk in, we'd have already gone through the motions, and we're picking a jury, and all of a sudden the prosecutor would drop off a box of stuff saying, here's your discovery, here's your Brady, here's your Rosario stuff.
So it's trying to find a middle ground in between those two, between making sure that they get everything with some time and that you also get enough time to give it away. Because part of like, how do you guys feel about the time being too short on giving stuff? Like, I'm pretty sure you love being able to get everything the day off.
Yeah, it's the sooner the better. It's better for us, because if it's something where there's information that, like, look, there's no doubt this happened. There's no factors that we can kind of work out to try to get a thing dismissed. And then it's the best option for us to discuss it with a client. Maybe there's a better option as far as making an offer. But if there's stuff that we don't know or we don't have, then really it's hard to inform the client about what the best option going forward is. I think it just makes the system better.
Christine, what do you think?
I don't disagree. I've always been of the practice in the mind, like good, bad, or indifferent, everyone should know exactly what the case is, because that's what it is, right? We're not here as prosecutors to lie or deceive. Like, we have to deal with the facts as they come to us and the cases that comes to us. So gamesmanship in any way like that with a prosecution, I don't think is justice at all for the victim or for the defense, which my obligation is to do that for everyone involved in the system. I think there's a characterization of prosecutors out there that all we want is to send people to prison. All we want is to, lock the jail cell and throw away the key. And that's not what my job is. That's not how I've ever been raised to be a prosecutor. It's to do what's fair and just for everyone in that courtroom. And although defense attorneys may not agree with that sometimes, or even my victims might not be happy with an outcome, that's my obligation first.
I have to say, being the fly on the wall in many places, you both suffer a different reputation. All three, meaning the PD, the public defenders, have a reputation of they're just the worst. They're useless. The DA has a reputation, like you said. They don't care about anything but to put you in jail no matter what. And Jim gets to enjoy the public defender's reputation if he's assigned. as a private attorney, he's a door if you're paying me full rate. But if you're assigned, you're useless because you're free. So you guys are already fighting battles aside from in-house lawyers and all kinds of stuff. Now, and this is gonna sound like a really stupid question, I'm sure, because some of the reports I was reading said that part of this whole thing is because there was an increase of dismissal cases because you couldn't get the DA couldn't get the staff ready and whatnot at about 455% increase in 2020. And part of the whole thing is going through the evidence given to you to give out to them. But if the rule says that everything has to be turned in, aside from, like, would witnesses information and stuff like that would be the only difference that why you can just grab everything and turn it in and you like have to go through every little bit beforehand.
I think you're saying that we able to get cases dismissed for the people not providing all the discovery. Is that accurate?
Yeah, like I said, like strict adherence to discovery timelines have led to a surge in case dismissal due to procedural error. For instance, dismissals have increased by 450% since 2020, with a current dismissal rate of 62% in New York City, aside from the rest of the state.
Yeah, I mean, we've had a significant number of dismissals throughout the state based on failures to comply with discovery. But in the cases that we
were warranted, or that they should have actually been followed through.
No, they're definitely warranted. It's situations where like vast amounts of discovery are missing. I can tell you that we don't file that motion unless in our opinion there's a lot of discovery that's missing and it's not accounted for. And in our opinion that it's not there. Minor things, ticky-tack things, we don't file that motion. And I'll be honest with you, I've seen other attorneys try to file the motions, and the courts generally, I mean, I can't speak for downstate, but upstate, judges aren't having it. They'll give the prosecutor at least a pass on some of the minor things. It's the ones that we've successfully done is just where there are things that are glaringly obvious that are missing that should have been turned over.
And it's a completely different thing. I imagine in here, I have no idea what a New York City courthouse looks like when it comes to Supreme County and murder and the volume that they must have. I mean, some of the files you get are what, terabytes in data, something like that.
Yeah, well, we have a bunch now where we get the discovery, and we need like hard drives to download it all, and it's a lot of. I know it's a lot of work for the prosecutor. I'm sure Christine can tell you more about that, but it's a lot of work for us because we're getting it, we got to process it, we got to make sure we're identifying everything we have, and then noting what we're missing, and then with the changes in May, I think it was May of 2022. We actually have an obligation now to let the prosecutor know, hey, you forgot something. Can you take a look at this again? So before we can even file that motion, now I have to tell the prosecutor, we're missing some stuff. Can you take a look?
Yeah, I mean, I do notice that you all, DAs, CDs, and stuff, have a very good relationship with all in all, at least in all the different counties and cities that I go to, where are we getting that much affected on a negative way by what's happening in New York City and having the same regulations that they do over there? Because it's like we're in a completely different state at this point, based on just how our courts run over here compared to downstairs. Or am I completely wrong on that?
I think there's a difference for sure. I think when you are in upstate, we have smaller legal communities. We deal with each other a lot. And so there's a different requirement to know that you're going to see these people again. And you can't just be in one courtroom once and then never see them or deal with them again. So I do think it changes. I do disagree with the fact of dismissals. We have seen an uptick in Wayne County. A lot of our judges have, although we now have different guiding standards from the Fourth Department, prior to that, when we were litigating things in local court on 90-day. So the dismissals that are being requested are actually, it's a two-part request. They're saying we haven't met our discovery standard, and then based on that, we haven't been ready in the time allotted to prosecute.
What is that?
Now, that is 30-30 time.
No, no,
So
after
defense,
30 days,
so for a misdemeanor, it's 90 days. For a misdemeanor. For a felony, it's 6 months.
okay.
So again, for a misdemeanor in a town court that it could maybe have 3 appearances in the time that the case is pending in the 90 days, maybe. And prior to court decisions, our judges were taking it to be a very strict liability standard. It wasn't a good faith and due diligence, which is what the statute said, because the argument that has always been put forward by defense attorneys is if something is missing, how much due diligence can you say you've really practiced? If you
Yeah, I
miss
mean, there's so
something,
many hours in the day to get it done.
right. So if you haven't, even if it is a small thing you missed, you still missed it. And so you couldn't have practiced due diligence because you missed it. And due diligence would have caught it. And since you didn't, you can't be ready. And since you can't be ready, the case needs to be dismissed. So New York City, based on volume, their numbers are going to just be higher in general when it comes to these types of issues and being able to do it. But I wouldn't say that we don't see it. I think that's kind of as the practice has gone on and court cases have come on to say, really there has to just be, we're not looking for perfect prosecutors because that's unreasonable. We're human. We're human still performing this job. So we deserve the opportunity to actually be held to a standard that's reasonable of good faith and due diligence. And so the courts started utilizing that standard and applying it to analysis of appeals under the new discovery law. And now that's clearly come forward in the discovery reform that was passed in the New York State budget, because I think everyone has found that that should be a standard and that we shouldn't be holding prosecutors to
How
an
did it change?
unachievable goal.
Sorry to interrupt. I thought my bad.
That's
How
fine.
did it change exactly? Like before it was 30 days and 6 months. What do you have now?
The timelines haven't changed. It's the language in it has changed to allow courts and give guidance to the courts more of what really should require the most extreme remedy, which is dismissal. So as a part of discovery, the people are required to file what's known as a certificate of compliance, saying we've done what we're supposed to do under discovery. We've turned all of these things over based on us now being in compliance. The people are ready for trial, and it stops that 30-30 clock when we can state we're ready.
Okay.
Prior to discovery reform, I could walk into court, hand Jim an indictment, and say the people are ready for trial without giving him discovery or any of the disclosures necessary. When discovery reform occurred, they directly tied the people's readiness to discovery, which was a thing that has had, I believe, and what has caused for these reforms to go through in the budget, these unforeseen consequences of these dismissals, because they directly linked our ability to be ready for trial and discovery compliance, and the negative outcomes and impacts that have resulted from that have resulted in now the reform in the state budget this year.
Now you say the negative impact that it was in context. There was consequential impact that it wasn't intended to. What kind of impact was that?
Well, it became it's become more of a sword than a shield, right? For defense attorneys and motion practice and doing these. Instead of it, as I would have read it and thought the intentions of the statute and discovery reform being to be like something that helps defendants, that protects them. We give them all of the discovery. So good, bad, or indifferent. They have everything. They know everything we know. And we try the case as it is. There's no gamesmanship. We're not hiding anymore. And that's how we move forward. But in a lot of cases, and what the reform and the goal of the reform is to take away this reform being used as a sword against prosecutors, and gamesmanship being done by some defense attorneys, that no matter what the prosecutors do, there will never be a prosecutor that practices good faith and due diligence. That a motion will always be filed. I haven't done a trial since 2020 where a motion for discovery compliance hasn't happened the week of or the day of jury. Because it has become an affirmative attack and defense, no matter what level of piece of paper or something that is missing or was missed by both parties until trial preparation. I think the legislature saw it. I think the governor saw it. And I think that's why they've tried to work it back to put some obligations on the defense to more affirmatively work with us, to put them on timelines for challenging our COC, as well as actually putting in the statute recommendations to analyzing whether our certificate of compliance is valid, including a standard of like good faith and due diligence and multiple factors, not just that strict liability that one piece of paper is missing, therefore there's no chance you did what you were supposed to.
Well, pretty sure some people at some point may have taken advantage of that, obviously. Now, somebody, like in this case, I know that towards in a trial, usually at some point, a lawyer, the defense lawyer always has a motion to dismiss. We want a motion to dismiss, the counsel has not been able to prove the burden beyond reasonable doubt and whatnot. Wouldn't these fall into something like that? Like there's a necessary step to make sure the defense attorney covers all their bases?
If that's me, and I would, for me, I think there's always an obligation to be a zealous advocate for your client. I do not doubt that. I know that is a duty that people take very seriously. I also will have a fundamental problem where I see motions that are coming in that everyone's had the same discovery for the same amount of time, and everyone's missed this one body worn camera for a deputy down across the corner of the street who wasn't in the CAD, but somehow somebody finally catches it right before trial, and that should result in a dismissal. The fact that there are motions all the time that come in and immediately question a prosecutor's good faith and due diligence, and I'm not saying that there aren't some that don't do the job the way they should, but when you show up,
Even if it's missing and you know about it, why not bring it up and just say, hey,
right.
can you hand me this before we
Let's
get
just do this together. I want to try the case as it is. I'm never trying to hide anything. That's never been my practice. That will never be any of my prosecutors' practices. But to constantly always show up and there never be, regardless of how small or big, the discovery violation. And the court, we've had cases in the Fourth Department, one from Ontario County saying, the DA showed up and said they didn't have it, they didn't have it. And that just wasn't good faith because there was stuff that they did have. Well, there was a case from one of my trials on appeal where the defense attorney emailed me, said, hey, random body worn camera missing, need it. Immediately got her the camera, figured out where it was, got it, sent it to her. And they said, okay, this was a case with a lot of discovery. Once it was brought to the prosecutor's attention, she remedied it. And so they found that I still acted in good faith and with due diligence, even though there was body worn camera missing, because there was no me repeatedly showing up to court saying, it doesn't exist, it doesn't exist. Like once it comes to my attention, I immediately address those issues because I never want to withhold things. It's never an intentional, deliberate thing. So it gets to be a difficult practice where it feels like as prosecutors, and I'm sure Jim has it when he's reviewing discovery, you feel like you're chasing your tail a lot because we aren't even talking about facts of cases anymore. We're talking about a note card.
What do you think, Jim? Because you have unlike somebody working for a specific office, you're like me. You get a bird's view of but you actually practice in all of those. I don't even know what the hell I'm interpreting half the time, because I don't understand law. Do you see that a lot? What is your take of it?
Well, I mean, I could say that. I mean, we've done a lot of motions throughout the state on this, and whenever it's come up, it's never like one piece of paper or note card that's resulted in a dismissal. I can tell you that's not the case. It's been usually a very significant issue. We've had a couple of cases where we pointed out we're missing stuff, and like Christine said, that the prosecutor would say, that doesn't exist, and all of a sudden, oh, there it is. So those situations have come up. But in the other cases that we've had dismissed, it's always been something like substantial. There's always been a lot of discovery that wasn't provided that clearly should have been found. It wasn't something that was overlooked. It was definitely within the course of the case itself. And I can say, through the counties that we deal with, a lot of counties really have this thing like locked down. Like they just knock it down. Like we've had cases in Erie County. And when the discovery, like when you put the notice of appearance in, they are immediately send you stuff. Like here's everything. And they just really have their system down solid where whatever it is you need, you got. And then there's really no chances for any of this dismissal stuff.
That's why we need to teach New York City and other bigger departments and areas how to be more like our area. Because you guys, and I am a witness, there are many different places, although the unified court system is very not unified, as we can see, because we need like silly rules for everybody to follow the same. Um, I just, I guess I'm a little confused as to why don't we make it, well, never mind that question. I was completely wrong. Sorry. My bad. So how do you see it happening for you now? How do you see it going forward? Like, are you excited about the changes? You don't think they're enough?
Well, I'm not real excited about it. No, I kind of liked what we had. Obviously, I mean, I think it was obviously very beneficial for the defense what we had. But in terms of I guess trying to get to the right outcome, I think it's maybe a step in the right direction. I don't think it's something where again, if we were missing stuff, we would still certainly reach out and say, hey, look, we're missing something. You want to take a look at this? We didn't immediately start dropping motions.
Yeah, I think what he means is like the kind of lawyers that they will go ahead and say, you know what, I got a murder on my hand that I know is guilty because I see all the video. There's no way of anything, and they're gonna use the we forgot to put the logo on this other page or put up, the cover page on the document, and now that's gonna get everything dismissed compared to let's all do our best and do, without that little trickery. I'm not talking that you do any of that because obviously I've known you're not that kind of lawyer. Most lawyers are not that kind of lawyer. Just like most in the field are they because they're passionate about just justice. Whether it's punishment, whether it's release, whether it's something, most of us are in it because we love the system and we want to make it be a tool. And I know you two are that kind of people as well. But I do see though how if you're telling me, you know what, I have 5 trials, they are all extremely high volume where we only get one every 2 years. And then all of a sudden I'm delayed for a month. I need another month to give you all the documents. I can see why that would be fair. But I can also see your point of now you're taking my chances of, if you're not ready, drop it. But coming from a country like Venezuela, I see that that's not bad a month or two though. And that's just my opinion. Because in Venezuela you get picked up and 2 years later you have your first court appointment to read your charges. Sometimes you don't even have it. You just get released again and out you go. So from my point of view, for example, it is completely not perfect, but I see that upgrade as in a good direction though, because it allows for the real criminals to be persecuted. It puts extra work on you though, because now, not you, but you as it puts extra work on the defenders, I should say, on the defenders because they're taking away that extra. You really only have this much time, kind of like in federal court where they say you only got 6 months or something to charge somebody, and then 2 years later, and it's like, well, but I still don't have an actual charge. Well, because the time keeps getting, postponed and not counted and whatever and whatnot. I don't know. I'm on the fence. I gotta say, because it does sound fair, and it doesn't sound like you're also not getting all the stuff like before. Like, here you go, a week before trial. How the hell do I get ready a week before trial with a terabyte of data and stuff to get through? I remember those days of TVs, and it was going crazy. And I remember now you guys going crazy as well because I don't have enough time on the day to get all of this done, and I don't have enough lawyers to hire or the budget to hire them to get it done as well. So I don't think my conversation is making either of you happy, but I do think that you both are getting a good end of it though, because it's going towards balance. It's not perfection. It's going towards a balance.
And that was the only goal. I mean, the DA's Association, when the governor approached us asking for support regarding these reforms, there was never any proposal by our association saying, go back to 2019, go back to 2020. Because we all readily admit that this is the way the system should be working. We should be turning everything over. We should be having full, fair disclosure of all of the evidence. Like, that's where we are now, and that's probably where we should have always been. That's always been the way I practiced. So it was, unbeknownst to me that there were people that didn't do it that way.
It's like,
So,
what? Are you crazy?
right. So that was very foreign. So what all we were trying to do was remove some gamesmanship from it, make it so there was at least some onus on defense to communicate with us fully, put them on a timeline as well. So we've got 35 days after we filed our certificate to challenge it, because the same way we're on the clock to try and review all of this discovery to make sure nothing is missing and get it to you, you should have the same responsibility back to us and letting us know that you're going to challenge because something is missing. And you don't get to wait until the 6 months is up and then go, sorry, you didn't get us that thing, and now we're going to challenge it, and now it should be dismissed. Like, that was really our goal.
Do they also get some consideration, like there gotta be some good faith mistakes sometimes in that? Because 35 days doesn't seem that much if it's a huge, because we're not worrying about little cases. We're not talking of the little cases over here. Those are, we're talking the big stuff that would be weeks of reviewing, just papers. Sometimes there are thousands of just pages alone. They're not even digital.
And there are extensions available. Yes, the court can give, if there's good cause for a delayed application, to challenge it. They allow those extensions for them, for the same reason that we should have some flexible time too. If there's a homicide that happens, that is hours of body worn camera easily. And how many agencies respond? How many officers within the agency? And you can see how quickly 6 hours for one deputy turns into 100 hours for the Wayne County sheriffs. And that's not even the troopers that helped out or responded, or Palmyra who held a perimeter, or anything like that. So again, I think all of it should be looked at in a scope that is like fair to everyone. And that was the goal in my advocacy for the change and the reform to discovery, was not to go back, not to get rid of it, not to say hold prosecutors to a standard to uphold the law and provide what they need to, and to practice fairly. Absolutely do that. I take pride in the fact that that's my job and what I do on a daily basis. But also get the gamesmanship out of it. Let's be adults in this room, have communication, and try the case for what it is and not technicality. Like, let's look at the facts and circumstances and really resolve this as we used to be able to have those conversations versus post 2020, where now it is, I forget times where we can actually talk about cases anymore and not discovery. We don't talk about them anymore.
Now, this might be a bad thing to say, but wouldn't be the same thing could be said about gamesmanship and like charging somebody twice for drinking and driving? One because it's technical and the other one because you walk it.
One, because it's,
You know how one is based on the field sobriety test and one is based on the actual chemical test?
right. Well, that's technically a violation of two separate laws. That's why you do it that way. Because, for example, Jim will make the argument that the test was, it was only a 1-0 and the stop was 2 hours before. So really the jury can look at it and believe that at the time when he was stopped, because you process drinks at different rates, he could have been stopped and he could have been a 0.08 or lower. So the test, you shouldn't even consider the test. And they might be, you know what, Jim, that's a good argument. We don't like the test. We'll get rid of the test. But then they watch him on the body worn camera and see that they're rumbly, bumbly, stumbly through the field sobriety test and be like, you know what? He still, even if we get rid of that test, he still wasn't able to operate that motor vehicle because based on our own observations of him, he appears to be intoxicated. So those are just different theories.
Okay, but you still get charged twice for the same thing. Because I mean, we've seen in cases, for example, I've interpreted in cases where they say he does not look drunk at all, but it's a burial language that is causing something to happen. For example, now the cop is saying you're drunk, and whether because misunderstanding of how the stab should be taken or something like that. Usually in the legal system, we're innocent until proven guilty, but you still come out of the other side of the sewage. Whether you came out innocent or not, you're still muddy because you have to go to court, you have to fight your stuff, and you know, you're still fighting it. And then you got two charges for the same thing. So, but again, that's not something done by the DA. That's something put into law itself. So it would be a completely different thing. It would have to be a change in the law itself.
Yeah, and I mean, that's frequent on any crimes, not just DWIs. For example, we have something that could be a home invasion, and you end up charging someone for a burglary because they broke into someone's home and had a weapon. You charge them with possession of the weapon. That's the same incident because they have a weapon. If they hurt somebody when they went in there, you would charge them with assault while they were in the home with the weapon. So most cases end up because you violate different statutes or subsections of the same statute. You can charge robbery under different theories if there are two people involved, and then there's also an injury. That's still two counts of robbery in the second degree. They're just different theories. So that happens frequently, and our obligation is if it meets the elements of the crime, we prosecute that.
See, that's why people like me, just regular Joes, we hear double jeopardy. Yeah, sure. Read the law. Uh, so I don't know. What do you think, Jim? What's your thought in this whole thing right now?
No, I think we made a lot of progress from 2020. I think it's a good step. I think for the most part, most of the prosecutors we deal with are like Christine. They're trying to do the right thing. It's the exception where the prosecutor is not doing anything or claiming they've done some inquiries and it's clear that they haven't. So I think overall, I think the system's better than it was. So I think it is moving in the right direction for sure.
These are what I believe to be generational changes. Because I mean, look at how long it took just to figure out a few kinks, 4 or 5 years. Then we gotta figure out what kinks come out of this, and not even kinks. It's just adjustment. It's like tuning a guitar. We keep adjusting and adjusting and adjusting until hopefully we get somewhere. Now, I don't know when will be the day that both sides will be completely happy with how the law works, but I don't know. Did you guys got asked about it, or was just the DA?
No, I mean, there was like surveys that were done that were passed around the defense community, and I think there's groups that the defense community had weighed in on opposing any of the changes that just recently went through. So collectively, I think defense attorneys throughout the state opposed it.
Do you know what was the main reason that they opposed on?
Well, I just think that the transparency they were getting, the information we were getting, I think was, it was a lot, but it was very helpful for us into making decisions for our clients. If we had everything, it's a much easier case to kind of talk to your client about versus if you're speculating on what you don't have, or if there's things that might be helpful or exculpatory, and not knowing, back in the old days before discovery reform, where you weren't getting anything until right before you picked the jury. It was obviously a big detriment to the defense.
Although it seems like now you'll still be able to get everything that you need. If not everything within that same 30 to 6 months time frame, you should have at least a very vast majority of everything to at least start doing better, prepare yourself better than pre-2020.
Oh, absolutely. Yeah, absolutely. With everything that we're getting, I mean, it's a much easier case that, some of the things that our clients would have, complaints about, pre-2020 were like, we didn't know about this, or I didn't know about that. I wouldn't have taken the plea offer, or I would have, I would have made a different decision on certain things if I had known this stuff. And then obviously, you're trying to represent.
Like my face is not seen in the video, but I didn't know that.
Right. So if there's things that are missing, and look, how can we advise you? Why did you tell me to take the plea, or why did you advise me to take the plea? And all of a sudden, you have stuff that was obviously things that we thought that maybe would have been good for a jury to try to decide.
Well, I actually appreciate you both because I think it gives me a lot of clarity on the side, at least to me. Maybe I'm understanding it wrong, but again, I also you hear so much noise, good and bad, about the governor, and I have no idea about her because I don't really follow what she does or doesn't. But at least looking into talking to the different sides of the aisle to find out, the points of views of both. And so far, I gotta say, I don't know, maybe I'm wrong, but I do feel that this is a positive step, though. I mean, be able to just find that out. You still get everything that you need to do, everything that you need to do to get your job, and whatever you don't do, then they have somebody breathing down their neck telling them what's going on. Are you gonna get it ready, or how much longer? And if not, then there's no reason for them to say, well, it was just tactics and anything else. Because now it removes it from this one is messing with me, that one is messing with me. I think it's actually a pretty good balance because now everybody gets a chance to do the job right, which is an important thing. And then there's accountability. You gotta be able to say what have you been doing with your time in this meantime. And so thank you so much to the both of you. Any final thoughts you guys want to share?
Jim?
No, I think I appreciate you guys having us on. I think I think it's a good topic. I think it's an important topic. I think like we talked about, it's definitely going the right direction. I think having all this information out there for people to know is very important.
I would love to have you guys anytime you're able to, because the way I see it, at least the way I feel it, regular Joes, we don't get that training where we're always using professional words, for example, right? We talk about it got disconnected. We don't say it got unplugged. So when talking about all those little things, you guys always have helped me to understand things in a more regular language. Well, I appreciate you guys joining me today and helping me with that. Maybe you will be kind enough to also inform me on other subjects, me and the five people who listen.
Whatever you need, Carlos, I'll be here.
Well, thank you so much to the both of you. I am honored because I honestly, I know how hard you both work, how zealous you are for your clients, whether you're looking for justice or you want to make sure that justice gets preserved. Like, I don't know. I don't want to sound too crazy. Anyway, thank you so much, you both. I hope you have a great rest of your evening. And I hope everybody else listening or watching the show, if you have any questions, send your comments on pkdkpod@gmail.com or follow us on Facebook. Have a great day, everyone.
Good.
Thank you for listening to today's episode. Don't forget to follow this podcast so that you don't miss any new episodes. You can also search for PKDK on your favorite podcast player for all the other shows that we have.